Hi, my name is Matt Eichelberger of Eichelberger Law Firm here in Jackson, Mississippi. We represent people who have been hurt at work or who have been charged with a crime, and we do that all across the entire state of Mississippi. We're based here in Jackson. There are multiple lawyers with us here in this firm, and I run the criminal defense division of this firm. I want to talk with you today about something called preliminary hearings in felony matters. Now, under Mississippi law, a person who is charged with a felony is entitled to a preliminary hearing so long as there's not been an indictment in their case and they demand it. Those are the only two requirements. You have to make a demand and you have to have not been indicted. Now, if a person makes that demand, they must have their preliminary hearing within 14 days. Otherwise, they are to be released on their own recognizance, except for certain special circumstances that generally don't apply to anybody who would be watching this video. Now, what happens at a preliminary hearing? Well, a judge is to make a decision as to whether or not there is probable cause to believe that the person who has been charged with a crime actually committed this particular crime. And then they generally address the issue of bail or release. So at the preliminary hearing, the state, the prosecution, they will put on a witness who will testify about the investigation and what led them to make an arrest of that defendant. Usually, and most times, I'd say roughly 9 times out of 10 or a little bit higher, the judge will find probable cause at the end of that hearing because it's a pretty low standard, at least compared to what we think of in criminal law, which is that famous beyond a reasonable doubt standard. That doesn't apply until the jury at trial makes a decision about guilt or not guilt. Okay, so this is an early preliminary matter that doesn't have that higher standard. All right, so a person will be put on the stand, usually an investigator by the state of Mississippi, to testify about what they found, why they arrested this particular person. Importantly, the defendant's lawyer then has an opportunity to cross-examine this investigator, this witness. During this investigation, they usually come up with some things that they want to share with the judge and some things they don't want to share with the judge. Well, the criminal defense lawyer can often step in and learn more about the case in a preliminary hearing than they can through most other methods. Also, this will be one of the rare opportunities that a criminal defense lawyer has to get a prosecution witness under oath about a case. That can come in handy later on at trial or even in pre-indictment or pre-trial negotiations with the state. I've seen that many times in my own practice where a witness will take the stand and they will say something that I then repeatedly use when talking with the prosecution about why they shouldn't prosecute my client or why they should give my client a better deal than maybe they were intending to give them. Now, at the end of that preliminary hearing, and notice I just talk about one witness because almost without fail, it's one witness at the preliminary hearing. At the conclusion of that part, the judge then looks to the defense lawyer and says, do you have any witnesses? 9 times out of 10 or higher, the defendant will not call any witnesses at this point. Usually the only reason the defendant would call a witness at a preliminary hearing is to establish some sort of defense to a crime, like a self-defense, an affirmative defense is what we call those, that might lead the judge to find there's no probable cause. We've seen that happen. We've seen that happen in murder cases where a judge, after hearing from a witness, sometimes the defendant, usually not the defendant, makes a decision that there's no probable cause based on everything that's in front of them that day. Now, at the conclusion of the preliminary hearing, the judge will decide to either bind the case over to the grand jury or dismiss the case. If the judge dismisses the case, it's not really over. It's over for that point in time. The person will be released without having to post any bail at all, and they will have no dates on which they are to return to court. But that doesn't stop the prosecution from taking the case to the grand jury. Now, the grand jury, if the judge finds there is probable cause, the judge will say, I find there to be probable cause, and I bind the case over to the grand jury. That's a secret body that we can talk about in another video. But if the person is bound over, the judge typically will then address bond or bail at the conclusion of the preliminary hearing. Oftentimes, we can get a judge to lower that bond amount at the conclusion of the preliminary hearing. There's sometimes some other things we can do too regarding bond conditions like ankle monitors and that sort of thing that are conditions on bond. Now, there is a way that the preliminary hearing can be bargained away in exchange for a lower bond. Sometimes that happens. We'll do that probably, I'd say, 30% of the time. What that means is the defendant gives up their right to a preliminary hearing in exchange for a recommendation from the prosecutor to the judge about a bond. Usually you do that in a circumstance where you have a really good idea what the case looks like against the defendant. If you're the lawyer, you do it when you have a pretty good idea of what the case is. You also will do it if you think that means your person can get out on bond. So those are kind of some general thoughts and guidelines about what happens at a preliminary hearing. If you have any questions about these or about anything else, feel free to contact us. We have a bunch of videos here on YouTube and elsewhere that you can use to kind of familiarize yourself with different parts of the process. One that I highly recommend is our ultimate guide to the pre-indictment phase of a felony criminal matter in Mississippi. That'll be linked here. Then there's one that's a guide to the post-indictment phase of a criminal proceeding. These are longer videos. So, again, have any questions, feel free to reach out to us. Thanks.